All right, so today we are continuing our discussion on discovery, and our conversation today will enter into or delve into discovery devices. Up to this point, we've discussed numerous matters as it relates to discovery in the federal judicial system. We introduced the major tools of discovery or discovery devices, which we will be discussing today. We've talked a little bit about the permissible scope of discovery under the federal rules. We've talked about certain limitations on discovery under Rule 26. We've talked about discovery from non-parties and privileges, as well as the work product doctrine and how you assert privileges or work product doctrine protections. We've also discussed experts in trial prep, as well as what happens when there is an inadvertent disclosure of protected information. And so now, today we enter into our discussion regarding discovery devices. So you will recall that there are five primary discovery devices by which parties may seek to obtain relevant information from their adversaries during the discovery process. There are the initial disclosures under Rule 26, and specifically Rule 26A. There are interrogatories under Rule 33. There's also a request for production of documents under Federal Rule of Civil Procedure 34, oral depositions under Rule 30, and finally, Rule 35, which provides for physical and mental examinations. There are additional discovery devices. In addition to these, one that comes to mind is the discovery device for request for admissions. We're not going to cover that or other discovery devices, but just these five primary discovery devices that are commonly used under the federal rules. And so let's start off with our initial disclosures that are captured under Rule 26A. Rule 26A requires parties to disclose certain information to one another at the beginning of the action. So once the action is commenced, Rule 26A provides that parties are obligated to exchange certain information or disclose certain information without being requested to do so. And Rule 26A outlines the specific information that is required to be disclosed under Rule 26A. First, the name, address, and telephone number of individuals who are likely to have discoverable information regarding the matter or the case, along with any information that may be used unless that information would be used for impeachment purposes. So, of course, the name, address, and telephone information of individuals who likely have discoverable information. Additionally, parties are required to disclose copies of all documents or electronically stored information, that being information stored on computers or in processing types of formats, as well as tangible things that the disclosing party has in its possession and may desire to use in support of its claims or its defenses. Parties are also, specifically for plaintiffs in matters, are required to disclose a computation of each category of damages that are being claimed by indicating along with that computation and providing along with that computation any supporting documents or other evidentiary material that would assist in or showing how those numbers were developed, unless that information may be privileged or protected from disclosure. And then finally, parties are required, and typically this applies to defendants or defendant companies. The parties are required to disclose any insurance agreement under which an insurance business may be liable to satisfy all or part of a possible judgment in the action. And so after these initial disclosures are made under Rule 26, the parties have an ongoing obligation to supplement or correct any information as relates to these initial disclosures. Rule 26E provides, 26E1 provides for this ongoing obligation. If the parties fail to disclose or supplement this information, then this failure may result in sanctions under Rule 37C, which we'll talk about a little later in this video. And specifically under Rule 37C1, this specifically provides for that information that may not be disclosed in accordance with Rule 26 may not be used as evidence at trial. So that's a fairly severe penalty if a party fails to disclose information or supplements that information on an ongoing basis. Additional penalties also may be applicable. In some instances or examples of additional penalties that parties would potentially be or undergo or be assessed with could include the court ordering the failing party to pay expenses caused by their failure, or the jury will not be informed, or rather the jury will be informed of this party's failure to disclose. So Rule 26 is a very important discovery device, and it's important that parties pay particular attention to not only who are disclosing who may have discoverable information, but what that information is, and doing so in the proper time frame as required under the rule. That leads us to our next common discovery device, and that are rather interrogatories that are provided for under Rule 33. Interrogatories are essentially written questions. Interrogatory is a fancy word for questions. These written questions are sent by one party to another party that the receiving party is obligated or required to answer separately, meaning each question has to be separately, and all questions that are answered are required to be answered under oath, meaning that they would be testifying to the truth of that knowledge under specific penalties. According to Rule 33, or rather according to Rule 26A, which should be read together with Rule 33, a party may serve no more than 25 written interrogatories on another party, including all discrete subparts. And so oftentimes interrogatories may be combined into multiple subparts. So you have the base question, if you will, and you may have, let's say, subparts 1 through 7, right, that are related to the overall base question. So those subparts would be included in the 25 written interrogatory limit as outlined or provided for under Rule 26A. Parties may agree to individually, or they may request leave of court to serve additional interrogatories to the extent those additional interrogatories would be consistent with Rule 26A. Rule 26B1 and 2. And Rule 26B just generally provides for the scope and limitations on discovery. So as long as the additional interrogatories comply with the scope and limitations on normal discovery, the parties can agree on serving additional interrogatories, or they may request leave of court to do so. Now, an interrogatory, when propounded to an opposing party, may seek an opinion, they may seek contentions that the other party may have, and they even may request the application of law to facts. And so oftentimes questions or interrogatories are asked in a particular way that suggests that the requesting party provides this specific information that's outlined in the questions. And these questions can again focus on various matters as it relates to the discovery or the overall matter at hand, or the overall case at hand. Now, when the responding party receives these questions, the responding party has 30 days to respond to these questions. 30 days from the date that they receive service of the questions, meaning that um, the responses must be provided to the requesting party within 30 days of receiving the questions. Parties oftentimes in practice may request an extension of time in order to respond to the questions, which is certainly allowable under the local rules. Specifically under Federal Rule of Civil Procedure 33D, responding parties have the option to respond by allowing the requesting party to either examine their business records. They can specify the records to be reviewed, and they can provide a reasonable opportunity to examine the records. Now, this particular interrogatory option really coincides with the Rule 34 request for production of documents, but it is an option that the responding party can elect rather than providing his or her responses in writing. And so, again, instead of providing written responses to the interrogatories that they may receive, they could elect to allow the requesting party to examine the business records that could provide responses or answers to the questions or the interrogatories that the propounding party has served. They can also specify the records to be reviewed and give the requesting party a reasonable opportunity to review or examine those records. It's important to know that interrogatories may only be issued to other parties in the litigation. Interrogatories may not be issued to non-parties. And that's important to know because you will see as we discuss additional discovery devices that there are different requirements regarding serving other discovery devices on non-parties. But as it relates to interrogatories may only be issued to or served upon parties in the litigation and not non-parties. All right, so that leads us to our next discovery device, which is found under Federal Rule of Civil Procedure 34, and that is the request for production of documents, ESI, which stands for electronically stored information, and the request for production of things. Under Rule 34, parties may request that other parties produce documents, electronically stored information, again, information that may be on computer systems or databases, or tangible things that they possess that fall within the scope of general discovery and limitations, again, set out in Rule 26B. A party under Rule 34 may also request to enter upon specific land or other property that the responding party may either possess or control in order to inspect the land or survey the land or photograph the land or any designated object or operation that exists on the land. And this is a very important thing. Say, for example, if you have a situation where there's a property dispute, a civil property dispute, and a survey of property needs to be done. Well, a party just can't enter onto another party's land without permission, right? And so this mechanism provides the requesting party an opportunity to formally request entry upon the land to either inspect it, take pictures of it, or whatever the case may be, in accordance with the general discovery, the scope rather of general discovery under Rule 26. Rule 34B1 specifically under the request for production lays out or outlines the procedure that a request for production must follow. And so importantly, the request for production must particularly describe each item or category of items to be inspected. So let's say, for example, that there is a huge piece of machinery that may be at issue in a breach of contract matter. And in order to ensure that the piece of machinery that's in dispute is the proper piece of equipment, and not another similar type of equipment, then a requesting party in their request for production may particularly describe this piece of equipment maybe by a serial number or some other identifying number or mark. In the request for production, the request must specify or describe this category or this item rather specifically that it desires to inspect. The request must also specify a reasonable time, place, and manner for the inspection. They can't just do a blanket request and show up whenever they want to. The responding party typically has to make preparation to allow the requesting party onto their property, and so the request has to specify a reasonable place and time in order to do that. And then finally, the request must specify the form in which the electronically stored information is to be produced. And this is very important, particularly in modern times with the advent of electronically stored information on computers and a lot of digital storage of documents, digital storage of information, etc. And so electronic discovery is an entire realm, if you will, of discovery that we won't delve into, but it is a very key and important piece of the overall discovery process. And so there are some specific rules that that must be abided by whenever electronically stored information is requested, and specifically under the formal procedures for requesting electronically stored information. The rules require that the form that electronically stored information is to be produced must be specified. The parties are obligated to, again, similar to interrogatories for requests for production of documents, the parties are required to respond to the request in writing within 30 days of being served with the request, or if the request was delivered under Rule 26D2, which is a requirement or an option rather to serve a request within 21 days or so after the initial service of the complaint, then the request in that instance would have to be responded to within 30 days after the party's first Rule 26F conference. You will remember that we talked about this Rule 26F conference, that once a matter is filed, shortly after the responsive pleadings are filed and the parties enter into the discovery process, that a Rule 26F conference is held. And so if discovery, or specifically requests for production, are served 21 days after the complaint, then in that instance, parties who are responding have 30 days after the Rule 26F conference to respond to the request for production. How must the requested information be produced? And so we talked a little bit about this specifically a few moments ago as it relates to electronically stored information. And under Rule 26F3C, parties are required to discuss any issues about disclosure, discovery, or the preservation of any electronically stored information, including the form or forms that it is to be produced in. And so a part of this discussion process, if you will, is relative to this 26F conference that I just mentioned. Parties are essentially required to get together and map out a game plan in terms of what format information that may be electronically stored should be produced in, any other information as it relates to disclosure of documents or other items that may be sought in discovery. If the parties are unable to reach an agreement regarding the form of production, then the requesting party may specify the form in which they would like the ESI, or the electronically stored information, to be produced. This is according to Rule 34B. In that instance, the responding party may object to the requested form, and then if the responding party so objects, must then specify the form that it intends to use to produce the requested information. Even if the requesting party fails to specify the form that it desires the information to be produced in, the responding party nevertheless must indicate the form in which it intends to produce the information. This is important when you think about electronically stored information, because documents may be produced, for example, or may be kept, for example, in a PDF file. And so if you desire to do a word search, and really now it's a little bit different since PDF files and Adobe type files are now a lot more flexible in terms of their searchability. Typically, or before the modern advent of technology improving and documents or files like PDFs being searchable, parties may desire or may have desired or requested that the documents be produced in a Microsoft Word format, or even older than Microsoft Word, a WordPerfect type of format, because those word processing types of programs allow for searchability by word. And so if a party was looking for a specific piece of information, they could just plug in a search word and they could go straight to it in a document. It's for reasons like this that the responding party has to specify the form in which it intends to produce the information, so that the requesting party can know whether it will need to bear additional cost in order to buy new software to be able to either view the discovery or to access the documentation or the information that is provided in some other way. If for whatever reason a party is dissatisfied with either the form of production that is requested, or meaning the way that the requesting party requests that the information be produced, or if the requesting party is dissatisfied with the way that the responding party intends to supply the information, then either party may petition the court for an order to resolve the matter. We'll talk about the particular device or the specific device that should be used in a bit should that situation arise. If you have a situation where there is no agreement that's made up front in accordance with Rule 26F, or the court doesn't issue an order, or the court isn't petitioned to issue an order, then the default standard for production of documents is found under Rule 34B2E, which provides that for documents where there is no agreement or no court order provided on the issue, then a party must produce documents as they are kept in the usual course of business, or they must organize the documents and label them to correspond to the categories that are made in the request. And so this is important in the event, again, that the parties don't confer and agree, or the court isn't petitioned to issue an order, then the responding party is required to produce the documents as they are kept in the usual course and scope of their business. Which leads us to our next discovery device, and that is the discovery device of depositions. And we will specifically talk about oral depositions and what they mean to the overall discovery process. And so it's important to understand that depositions involve essentially taking testimony of witnesses under oath prior to or in advance of trial in order to obtain discoverable information, right? And so a person or a witness may be deposed and they may testify to some document or some information that could then be obtained and used to support a party's case as evidence, right? It's also important to note that depositions may be oral or written. We'll talk more here about oral depositions. It's important to know that for oral depositions, counsel for both parties essentially question the witness very much like a witness would be questioned at trial, right? The questioning begins with the attorney who requested or noticed the deposition, and followed by the defending counsel, if you will, or other parties in their line of questioning. For oral depositions, the deponent's testimony is recorded by a court reporter or a stenographer the same way that testimony is recorded during trial. I did mention that depositions can be written. In the instance of written depositions, those questions are essentially served in the same manner that written interrogatories may be heard. But written depositions are very rare in contrast to oral depositions. Oral depositions are more prevalent because it really gives parties an opportunity to see a witness in person, particularly if it's a defendant who has an opportunity to see a plaintiff for the first time. Depositions give parties an opportunity to observe what type of witness the deponent will make. Does the deponent present well? Does the deponent address well? Does the deponent come across as nervous? Does the deponent come across as educated? Does the deponent come across as resistant to answering questions? So all of these things, parties have an opportunity to observe in person during oral depositions. It's important to note that deponents do not have to be parties to the action. And so, pursuant to Rule 30A1, any person who has information about a case could be deposed. In the instance that the deponent is a party, then, as I mentioned a few moments ago, the party desiring to take the deponent's deposition initiates the deposition by sending a notice of deposition to all parties in the action. And this notice states the time and place that the deposition will occur. If the person to be deposed is not a party, then typically a subpoena also accompanies this notice of deposition, according to or pursuant to Federal Rule of Civil Procedure 45. In the event that the counsel who is deposing the witness, right, wishes a non-party deponent. So this is a person is being deposed who is not a party. Let's say, for example, an expert, a medical doctor, or an expert economist, let's say. If the deposing counsel wishes a non-party deponent to produce records or other tangible evidence that may be used in support of the testimony provided at the deposition, then the deposing counsel must also serve what's known as a subpoena ducis tecum along with the notice of deposition. Now, this subpoena ducis tecum commands the party being deposed to also produce the requested items, right? This requested tangible evidence, to produce that information along with showing up or being present for the deposition. Oftentimes, a notice of records deposition may issue, right? And so in those instances, an individual is not necessarily being deposed, but what would happen is the subpoena ducis tecum that is notified or noticed to the responding party outlines the information that's being sought. So think, for example, in a personal injury matter, if there's a dispute as to whether the offending party was on the phone at the time of the accident, plaintiff may notify or send notice to the defendant's cell phone carrier company, specifying the phone number of the defendant, the date and time of the accident, and a range, if you will, of a date range of all of the calls that the defendant may make to be able to narrow down to use as evidence whether the defendant may have been on the phone at the time of the accident. In that instance, the plaintiff would serve on the phone company a subpoena ducis tecum, requesting that these records or these phone bills be produced at a specific time and place and on a specific date as a part of this case. As long as the party provides the requested documents in advance of or at the time of the time that's requested within the notice, then a person is not obligated to show up and give any sort of testimony. In the instance, and this is a common case, but it's really not very normal in the context if you're not used to doing it. But commonly, corporations are sued, right, or are parties in legal suits. In the instance that an entity or corporation is the subject of a deposition, then Rule 30, specifically 30b-6, outlines the procedures that are required for deposing an entity. So one may ask, well, how does a requesting counsel depose a corporation? If I've had a slip and fall incident in Target, how would my lawyer depose Target, right? Well, in those instances, Rule 30b-6 of the federal rules provides the procedure as to how to do it. If an entity or corporation is the subject of the deposition, then the party taking the deposition sends a notice of the deposition to the corporate entity. And that notice describes the specific topics that the requesting party would like to cover in the deposition. And so, for example, it could be that there is some evidence that exists that the incident may have been captured on video. And so the notifying party may want to depose the corporate entity or its representative who has information or knowledge about how the surveillance system works. And so once the entity, the corporate entity, receives the notice of deposition, they are required to designate an individual to respond in the deposition on behalf of the organization. In practice terms, this is known as the 30b-6 deposition or the corporate deposition, which is a very important discovery device or discovery tool used when conducting depositions. Now, we talked a little bit already about the format of depositions and the fact that the format of depositions essentially mirrors the format of witness examinations during a trial. The attorney who is conducting the deposition and who notices the deposition examines the deponent first. They get the opportunity to ask the questions of the person being deposed first. And these questions must be in accordance with the scope of discovery as outlined by Rule 26. The counsel who represents the deponent is known as the defending counsel or the defending representative. And this counsel may object to questions that are being asked by the deposing counsel on a number of grounds. So, for example, the information may not be relevant, right? And so they can object on grounds of relevance. They can object on other grounds, privilege grounds, etc. However, unlike when a party is at trial, the witness is still usually required to answer the question, even if she has an objection to it. Under Rule 30C2, when an objection is made, the rule provides that it shall be noted on the record, the objection shall be noted on the record, but the examination is required to continue to proceed, and the testimony is taken subject to any remaining objections that may come up. Counsel may only instruct its client or the deponent that it represents or defends not to answer a question in certain limited circumstances. And the one that most common arises or comes to mind is those instances where they may desire to preserve a privilege or enforce a discovery limitation that may have been previously set by the court. Counsel for the deponent or the defending counsel also will have an opportunity or the right to cross-examine the deponent after the deposing counsel, that is the counsel who notified the deposition, has finished his examination. Now, why would a person who defends a party or who is the counsel for the deponent, why would they want to cross-examine their own client? Well, oftentimes they may depose their client, or they may question or cross-examine their client, rather, to clarify statements that may have been made during the direct examination by the deposing counsel. If you have a situation where you have multiple parties in a suit, and each party is represented by his or her counsel at the deposition, then each lawyer will have an opportunity to ask questions of the deponent, or in this instance, cross-examine the deponent if they were not the notifying counsel. A couple final matters or final issues regarding oral depositions. The use of oral depositions in court is subject to certain limitations that are outlined by Rule 32. And these limitations include uses such as for impeaching a witness or offering testimony when a witness isn't available at trial. What this means is that if a deposition is taken and of a particular witness, and that particular witness also testifies at trial, and let's suggest, or let's assume that at trial the witness offers testimony that was different from the testimony that was offered during the deposition. Remember, the deposition testimony is taken under oath. Then you may have an opportunity for a credibility question, right? And so this notion of using a deposition for impeachment is a term of evidence, which simply means that at that time, the deposition may be used to suggest to the deponent or to suggest to the witness at trial that the testimony that they previously provided while being deposed is different from the testimony that they're providing while at trial. And so this use of a deposition for impeachment purposes is extremely important when trial proceeds. Important to note also is the limitations on the length of time that a deposition may be. Under Rule 30D1, depositions are limited to only 1 day and for a maximum amount of 7 hours, unless the parties agree otherwise or the court allows additional time. But importantly, after 10 depositions have been taken in a matter, then leave of court is required to conduct a deposition, unless the parties have, again, stipulated or agreed to more depositions. And that rule is captured in both Rule 30 and Rule 31. All right, so that wraps up information on the discovery device of depositions. And the last discovery device that we will discuss or cover is the discovery device of physical and mental examinations. This is a very important the discovery device that is used throughout the discovery process. Rule 35 under the federal rules allows for a party to conduct its own examination of a person's physical or mental condition if that person has made his or her physical or mental health an issue in the action. So, for example, if a person in a personal injury matter suggests that they may have suffered neck pain and back pain, and after treating with their orthopedic surgeon, their orthopedic surgeon suggests that they need to undergo surgery in order to repair the damages that they sustain, then the opposing party would get an opportunity to conduct a separate, independent physical examination of that party. Now, as you would imagine, because these types of examinations tend to be very intrusive, then the parties must obtain a court order for another party to conduct a physical or mental examination. That's very important. And sometimes that is a fact that's kind of glossed over by some parties, but particularly for plaintiffs, if you are representing a client who is being requested to undergo a physical or mental examination, it is extremely important to make certain that either a court order is obtained requiring the plaintiff to undergo that examination, or that you enter into a stipulation or an agreement with the opposing party regarding the time, scope, and manner of the examination. Additionally, these types of examinations will only be granted for good cause. And we'll talk a little bit about what good cause means in a minute. As you think about Rule 35, there are a few critical components that are required under the rule. First, the person who is to be examined must be a party to the litigation, or somebody under the control of a party. Non-parties typically cannot be subjected to undergo a physical or mental examination, right? The person to be examined has to be a party. The party's mental or physical condition must be in controversy. And this is a very critical area as well. If a person is only suggesting that they may have been injured physically as a result of someone else's fault, then an opposing party cannot request that that person undergo a mental evaluation or a psychological evaluation, right? If the mental or psychological condition of that person has not been placed in controversy. So that's an important component of Rule 35. And then finally, the party who desires the examination must demonstrate good cause to justify the examination. Now, having practiced for a number of years, I can tell you that this good cause piece is a major bone of contention, right? Because oftentimes defense counsel who represents defendants typically suggest, if a person has filed a lawsuit and they suggest that they injured a certain body part, or they've suffered certain mental injuries, then there automatically should be good cause to justify the examination. However, a key case that was handed down by the Supreme Court in 1964 begs to differ with that opinion. In this case, this is the case of Schlagenhoff versus Holder, which sets what has been come to be known as the Schlagenhoff standard. Schlagenhoff set the standard that determined that this good cause requirement and the in controversy requirement set out under Rule 35 dictate that sweeping examinations of a party who has not affirmatively put into issue his own mental or physical condition are not to be automatically ordered merely because this person has been involved in an accident and a general charge of negligence has been lodged. Schlagenhoff specifically says that mental and physical examinations are only to be ordered upon a discriminating application by the district judge of the limitations prescribed by the rule. In other words, there has to be some justification to demonstrate, one, that the requested physical body part or mental condition of the person to be examined not only is in controversy, but there have been some allegations to suggest, right, that a person has suffered some sort of mental deficit, or a person has suffered some sort of physical deficit regarding a body part that is to be physically examined. And so note the requirements under the Schlagenhof standard and what the requirement stands for. A final couple pieces of Rule 35. After the examinations are conducted under Rule 35, the examined party may request a copy of a detailed written report of the examiner's findings. So understand, under the rule, what typically happens is if once a court order is obtained for the party to undergo a physical or mental evaluation, then the opposing party selects the examiner to conduct the examination. So again, let's say that the party to be examined has suffered a neck injury, and they have a recommendation to undergo surgery from their own treating orthopedic surgeon. For a Rule 35 physical examination, once it is either ordered or agreed to, the parameters are agreed to by the parties, then the opposing party selects a different orthopedic surgeon, usually independent, or not usually, but that is independent from the plaintiff's treating orthopedic surgeon, who examines the plaintiff and renders an opinion as to whether this plaintiff really needs to undergo surgery. And in conjunction with this opinion, typically authors a report of his findings. Rule 35B1 suggests that if a finding is authored, then the person who is examined has the right to request a copy of that report. However, it's important to note that if the examined party requests such a report, then the party that requested the examination is also entitled to receive copies of any reports that the requesting party may have, or his examination, his examining physician may have had to provide or be subjected to for the same condition. So in other words, the examined party has to produce any reports from his own examiner to the requesting party. So if the plaintiff in our example has a treating physician, and this treating physician has authored any sort of report as to the necessity of the neck surgery, then that treating physician has to provide a copy of his report to the opposing party. Finally, the examined party in these instances waives any doctor-patient privilege concerning testimony about all examinations that relate to the condition that is examined under the rule. So that really captures all of the important discovery devices under the federal rules. Now, what happens when the parties may get sideways about discovery information that is requested, and they get into these back and forth, right, or these disputes regarding discovery requests? If a party can't agree, or if the parties can't agree, or if a party refuses to comply with the discovery request of another party, then the parties are obligated to confer to try to reach some type of agreement or resolution regarding the discovery request. If they aren't able to reach resolution, then the affected party may approach the court to seek an order to resolve the dispute. Now, when you get to this point, there are two types of relief that are available depending upon which party is requesting the relief. For the party who is trying to obtain the information, let's say if it's a party who's requested that another party produce certain documents under Rule 34, request for production of documents. The requested party refuses to produce these documents, and so now the aggrieved party has to approach the court for relief. That party would file a motion to compel under Rule 37. What about if the party who refuses to produce the documents desires not to produce desires not to produce the documents, then what relief is available to him? That party could file a motion for protective order under Rule 26. And we've talked a little bit about the specifics of a protective order already and what is entailed there. So let's talk a little bit more here about a motion to compel, which could be filed under Rule 37. Rule 37 allows a party to, let's go back here. Rule 37 allows a party that's seeking production of information to file a motion to compel with the court in order to compel production of the information that is sought. If this motion is granted, then the court would order the resisting party to disclose whatever the information that is being requested. The motion can compel disclosure of information that is required to be disclosed in advance under Rule 26. Remember that we talked about earlier in our discussion today, as well as the motion to compel can request appropriate sanctions for the party's failure to disclose or produce the information previously, or stated differently, as a result of the party having to seek the court's intervention to compel disclosure, then that requesting party can also request sanctions for the disclosing party's failure to disclose. A motion to compel can also compel a response for other types of discovery devices. A motion to compel is proper to compel, or proper rather to file when a party has failed to answer a deposition question under Rule 30 or 31. So remember, when we talked about oral depositions, if a party is instructed by his or her counsel not to answer, and the parties cannot come to some resolution of whether the deponent is required to answer the question or not, the aggrieved party can file a motion compelling the deponent to answer the question. A motion can also compel a response for failure of a corporation or entity to designate the proper party to respond to discovery or deposition under Rule 30b-6 or Rule 31a-4. So again, in those instances, when a corporation is requested to undergo and complete a deposition, if the corporation fails to designate a corporate representative, then the aggrieved party can file a motion to compel the corporation designate a representative. A motion to compel can also be filed for failure to answer an interrogatory under Rule 33, or for failure to produce documents or allow for an inspection under Rule 34, like we just discussed. If the disclosing party, again, desires not to produce the requested information, then that party can seek a motion for protective order under Rule 26C. If the court grants a motion for protective order, then the court would issue an order that the information is protected from discovery and doesn't have to be, or is not required to be, disclosed. The court may also order that the material be disclosed, but only be disclosed in a limited manner that addresses the disclosing party's concerns, whatever they may be. So think back to when we discuss privilege logs, right? If a disclosing party suggests that the information that's being requested is privileged, then the court may order that the information be produced under a privilege log, or it may order that the information be produced what's called in camera, meaning that it's not made a part of a public record, but it's only produced for the court to review in its offices, in his or her offices, and then required to be shielded or from any further disclosure from that point. So that concludes our discussion on discovery devices and ways to resolve discovery disputes. So I know it was quite a bit of information, but I think that this information is extremely important, as well as is information that is commonly used when you or when a practitioner finds himself or herself in the throes of litigation. And so it's important to be familiar with these discovery devices and how to avail yourself as a practicing attorney of forcing, or rather, of the techniques to force disclosure of information requested under a discovery device, or to seek that information from being produced. So I appreciate your time and attention, and we will see you on our next video.